Good morning.
Good morning, everybody.
My name is Vandana Kannan, and I'm an insurance arbitrator. I'm also the course coordinator for the 6-month-long online insurance arbitration certificate course offered by AIIRM. It is my privilege and pleasure to extend a warm welcome to everyone present here for this webinar on the topic Primacy of Arbitration over Litigation. The webinar is organized by ACDR, ASEAN Center for Dispute Resolution, a unit of ASEAN Arbitration Foundation in association with AIIRM, ASEAN Institute of Insurance and Risk Management. Today's discussion centers on the significant advantages of arbitration over traditional litigation. We are honored to have with us an exceptional lineup of speakers, including thought leaders, seasoned arbitrators, and legal experts who will guide us through this critical subject with their insight, experience, and expertise. I would like to welcome here Mr. Masood Wahab to give a formal introduction and welcome speech. Mr. Wahab is the Senior Advisor, AIIRM, and Director, ASEAN Arbitration Foundation. He also holds the position of Secretary General, ASEAN Center for Dispute Resolution. Mr. Wahab joined the insurance industry in the year 1981 as a direct recruit officer of Oriental Insurance Company, and he has worked in almost all the departments of an insurance company during his tenure, and he retired as the regional manager from the company. His contribution to Corporate Training Center College of Oriental Insurance has been immense, and he is currently a visiting faculty to many institutions, some of them being NIFM, ICAI, CBI Academy, to name a few. He is the force behind the ISCC course, which is now soon going to run its 7th batch online. Ladies and gentlemen, Mr. Masood Wahab.
Thank you very much, Mrs. Vandana, for your kind words. A very good morning to everyone. All of distinguished speakers and all the participants and all the attendees. I'm very happy that today we have been able to hold the webinar on the occasion of the valediction of the arbitration certificate course. It's a moment of great joy for us that we have been able to complete the 6th batch. Generally, our courses are for 6 months, but for this course, we took more than 6 months, 6 months, 20 days to be precise, because in between there are a lot of festivals and make provision. But I'm sure the participants of insurance arbitration course mustn't have felt tired. Attending the classes for all the 6 months. And this is an occasion for us to invite all people who are not just associated with us, with our Institute of Insurance and Risk Management, but all the people who are associated with insurance in one way or the other. I hope I'm audible to all.
It's okay. Yes, you are, sir. You are audible.
Okay. So once again, welcoming you all, and especially those of our senior speakers. Just by way of introduction, our institution, ASEAN Management, we started way back in 2003. And we started this course of insurance arbitration certificate course in 2021 when the Arbitration Act was upgraded or revised. And at that time, and we found that there was a lot of interest amongst the people from the insurance industry for, working as arbitrators. So we started this course, and I believe this insurance arbitration certificate course is the only course being run in India. I hope I'm not wrong in this. In India, but surrounding countries also, because we keep on getting applications for admission from surrounding countries. Of course, we are not able to accommodate them because of the time differences. And this course has since continued, and we have completed 6 batch. That shows the sustained interest in the people, and as arbitration is becoming strong in this country. Of course, it's not yet strong enough to pull in the insurance company because the insurers are still reluctant in this. But nevertheless, we are building a force, or I will say a pool of very qualified people who can be used as arbitrator by not just the insurance industry, but also by the people who are insured and they need to have an arbitration with the insurance company. So we have at present more than 100 people who are there in the pool, very, very qualified people, very senior people, very seasoned people, they're experts in their fields. So I feel that personally in India, as an insurance institute, we are having the largest number of qualified expert people on our panel. And that is a privilege, and that's an honor for our institution. And we in 2021, we've thought that since these people are taking or they are doing this course, so why not set up a company for doing arbitration? So we set up a company, ASEAN Arbitration Foundation, and under this company, we also set up this ASEAN Center for Dispute Resolution. So this ASEAN Arbitration Foundation and it Arbitration Wing ASEAN Center for Dispute Resolution was set up in 21. And with this hope that as an arbitral institution will ultimately be recognized. And we are hearing that the regulation for institution is in the making. And as soon as it is proclaimed, I hope that our institution, that is ASEAN Center for Dispute Resolution, will be recognized as an arbitral institution. And once it happens, then most of the powers which at present, as far as arbitration is concerned, will hopefully be transferred to these arbitral institutions. So today we are an institution, ASEAN Institute of Insurance and Risk Management. Today we are also an arbitral institution, ASEAN Center for Dispute Resolution. That in India, we have this unique distinction of being in both the places, being teachers and trainers, and we being also arbitrators. So on this occasion of the valediction of the 6th batch certificate course, we are having this webinar in which we want to have a discussion on this aspect of arbitration, how it is better than litigation. So having a look at the primacy of arbitration over litigation. And for that, we have invited some very distinguished people. We have Mr. Pratap Venugopal, who is a senior advocate, and he's also the chairman of ASEAN Arbitration Foundation. Unfortunately, today on got an urgent notice from the Supreme Court for a hearing of a case of SEBI. He's a representative of SEBI. So today he is there in the Supreme Court for the whole day. There is a case pending for which the hearing was not complete. So today hearing, but then he is not here in the sense that he will not be able to speak directly, but he has sent us a video recording which will be played for you. And the topic which he'll be talking about is the primacy of arbitration over litigation. That is the topic of the webinar. But it will not be complete if Tab speaks as far as from the legal perspective. So we have invited Mr. Arif Huda also, who is the former CMD of United India Insurance Company, to speak on the subject of primacy of arbitration over litigation from an insurance perspective. And I hope that once you have both the perspective, the legal perspective and the insurance perspective, then you will be able to yourself, understand or realize that arbitration is the best way forward, especially in commercial contracts. And I'm very happy that we have with us Mr. Sanjay Joshi, who is presently the General Manager of United India Insurance Company. He will be speaking as far as the disputes resolution in the insurance companies are concerned. And we have especially invited him for the simple reason that we had a market survey done amongst the people who are taking insurance to find out from them how happy or how satisfied they are with the services offered by the insurance companies, and especially in terms of resolution of disputes. So I hope that some of them have joined because we had invited all those people who had participated in the market survey. And Mr. Sanjay Joshi's talk will be interesting for them because he'll be speaking as an insurer today, especially how insurance company, not just his company, all other companies are, resolving disputes. What are the different tools which they resolve disputes? It's a coincidence only that both Mr. Arif and Mr. Sanjay are from the same company. They're most both welcome. We also have with us Mr. JP Singh, a very senior advocate and one of those persons who is specialized not just in arbitration but mediation. Very, very busy schedule. He has accepted to be here in the webinar. And last but not the least, my very senior colleague, a very senior person from the industry, Mr. who has been the CMD of General Insurance Corporation of India. He was, of course, my senior in Oriental Insurance Company. I'm very happy that he's there with us. And with these words, I would like to welcome all of you once again. And I'll now Mr. Amandeep Singh to kindly take up this first session, coordinate this first session. And I'd like to say a few words about uh, our colleague, Mr. Amandeep Singh. He is the of this course, and he has been in this course from the second batch. If I'm not wrong, Mr. Amandeep Singh, sir, he's been in this from the second batch, and he. Right. Yeah, he grew over the course, and we ultimately found that he's one of legal and insurance. And just a few words about him. He actually joined prior to joining insurance company. He was with a bank, that is Punjab and Sindh Bank. And at present, he is an advocate, Punjab and Haryana High Court, Chandigarh. He's also a legal advisor to the PSU insurance companies and a faculty and HR consultant of National Insurance Company. And he retired in the capacity of Chief Regional Manager of National Insurance Company from. So his has been a career of both from the legal side and from the insurance side. So he's a blend of both. And he's the ideal person for being director of this course of insurance arbitration certificate course. So I'll request him to kindly coordinate this program, introduce in detail all the speakers. And of course, when this, we'll take up this topic, the topic of the program, that is primacy. So we will first play the video of Mr. Pratap, and then Mr. Arif Huda. So, Amandeep sir, I'll request you to first introduce Mr. Pratap, and then we'll play the video of Mr. Pratap.
Thank you, sir. Thank you, Hab sir. In fact, at the outset, I would like to welcome our veterans from the insurance industry, Shri Yogesh Lohia sir, Shri Arif Hooda ji, Mr. Satinder Singh, Shri Sanjay Joshi ji, and a very senior advocate, Shri JP Singh ji. And in fact, this certificate course, when we thought of doing, it was, as Wahab sir has indicated, that that was a time of pandemic, and we started, thinking of initiating this course after the amendment of the Arbitration and Conciliation Act in 2019. So to begin with, the introduction of Shri Pratap Venugopal, who is the chairman of ASEAN Arbitration Foundation and a designated senior advocate having more than 3 decades of his experience in the legal field. He is a corporate and commercial senior advocate who is dealing with not only the domestic arbitration but also the international arbitration disputes. And he has been associated with very number of good cases on securities exchange, and he is on the panel of SEBI and involved in landmark cases like Sahara and PACL cases, Nirma versus SEBI. And he took over as managing director of the law firm KJ John and Company in 2001. And what to say about Mr. Pratap Venugopal? He is such a humble person, and I distinctly remember that he always gives his credit of his being entering into the legal side, as initially he did his BSc in microbiology and then pursued his legal education as LLB from Kerala University. And he always gives his credit to his father, who is a banker, and mother, who is a lecturer and poet, for the upbringing of him as a learned strategic thinker, and having understanding of the love and language of reading and communication as he had from his mother. Very experienced person, and in fact, he has been associated with us for a long time with AIIRM and ACDER, and as a talked about as faculty to the participants on arbitration and commercial law. He has been instrumental in creation of this Arbitration Foundation as a company, a non-profit company. And as we propose to have this arbitral institution, because with the coming up of amendment of Arbitration and Conciliation Act in 2024, where the Department of Legal Affairs of the Ministry of Law has already circulated the comments from the public for the amendment being proposed in the Arbitration and Conciliation Act, where institutional arbitration would be the coming field. And in line with the ease of doing business and in line with the global practice of handling the litigation through arbitration. So the government is very keen to set up the arbitral institutions, and AIIRM is ahead, and ACDR has already you see, have run 6 batches, as Wahab sir has indicated. So in all this, Pratap Venugopal
we will now listen to his recording, Mr. Amandeep Singh.
So I will request Wahab sir to start with his recording.
Yeah, please.
Distinguished guests, Mr. Masood Wahab, Secretary General, ASEAN Center for Dispute Resolution, Mr. Amandeep Singh, Director of Insurance Arbitration Certificate Course, esteemed colleagues, students of the 6th batch of the Insurance Arbitration Certificate Course, ladies and gentlemen, wish you a very good morning. Today, I would like to discuss a pivotal aspect of the Indian legal landscape, namely the primacy of arbitration over litigation. In an era where efficiency and expediency are paramount, arbitration emerges as a beacon of hope for resolving disputes in a manner that is not only swift but also cost effective. Arbitration, as we know, is a form of alternate dispute resolution, or ADR, where parties agree to submit their disputes to one or more arbitrators rather than pursuing traditional litigation in courts. This method has gained significant traction in India over the past few decades, primarily due to its numerous advantages over conventional court proceedings. One of the most compelling reasons for the preference for arbitration is its efficiency. The Indian judicial system is often burdened with an overwhelming backlog of cases. According to the National Judicial Data Grid, as of 2021, there were over 3.5 crore pending cases across various levels of courts in India. This staggering number highlights the urgent need for alternative mechanisms like arbitration that can alleviate this pressure. As the former Chief Justice of India, Justice D.Y. Chandrachud, aptly stated, the judiciary must be accessible and efficient. Otherwise, it loses its relevance. Moreover, arbitration offers parties greater control over the process. Unlike litigation, where judges dictate procedures and timelines, arbitration allows parties to choose their arbitrators, that is, experts in the relevant field, thereby ensuring that decisions are made by individuals who possess specialized knowledge pertinent to the dispute at hand. Another significant advantage lies in confidentiality. In contrast to litigation, which is typically public, arbitration proceedings are private affairs. This confidentiality can be crucial for businesses seeking to protect sensitive information or trade secrets during disputes. As articulated by Professor Sandeep Singh in his analysis on arbitration practices in India, confidentiality ensures that commercial reputations remain intact while disputes are resolved. Furthermore, arbitration awards are generally recognized and enforceable internationally under treaties such as the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards, 1958. This international recognition enhances India's attractiveness as a hub for global commerce and investment. However, it is essential to acknowledge some challenges facing arbitration in India today, such as issues related to enforcement and instances where parties attempt to undermine arbitral awards through litigation. Nevertheless, recent legislative reforms have sought to address these concerns by promoting timely resolution processes and minimizing judicial intervention. In conclusion, while litigation remains an integral part of our legal system, it is clear that arbitration offers distinct advantages that align with contemporary needs for speedier resolutions and expert adjudication. As we move forward into an increasingly complex world marked by rapid globalization and technological advancement, embracing arbitration will not only enhance our legal framework but also foster a more conducive environment for business growth. Former Chief Justice of India, Justice D.Y. Chandrachud, has emphasized that the efficiency of arbitration lies in its ability to provide parties with a quicker resolution while maintaining the integrity of the judicial process. By promoting arbitration, we are not only alleviating pressure on our courts but also ensuring that justice is delivered without unnecessary delay. As we reflect on these points today, let us remember what Sir Herbert Edward Reed, an English art historian, poet, literary critic, and philosopher once said, "I can imagine no society which does not embody some method of arbitration." In our context here today, choosing arbitration over litigation reflects strength, it reflects foresight, it reflects a commitment towards building a more efficient justice delivery system. I would like to take this opportunity to wish the students of the 6th batch of the Insurance Arbitration Certificate course who have successfully completed the course the very best in their future endeavors. Thank you.
So this was a recording sent by Pratap sir. In fact, he was busy today. Now I would like to take the honor of introducing Shri Arif Hudaji, who was retired as Chairman cum Managing Director of United India Insurance Company in 2016. He started his career in 1980 with National Insurance Company as Director Group Officer, and thereafter on promotions he went to United India in 2008 as Assistant General Manager, and Sir was remained as Independent Director of Canada Assurance Company, Kenya, and Agriculture Insurance Company, and apart from that, he was Independent Director of SLO India Limited also. He's having more than 33 years of experience in the insurance field, and also had the occasion of being a senior director in Marsh India Insurance Brokers from 2017 to 2020. And now he's a very prominent insurance consultant in the field of insurance laws and arbitration. And having said that, I had the fond memories of working with him and being associated in national insurance. Such a great personality we have. We are blessed to have him today. I will request Arif sir to take over.
Good morning. Respected Mr. Masood Wahab, Secretary General, ACDR, Mr. Lohia, ex-CMD of GIC, Mr. JP Singh, Senior Advocate of Supreme Court, and other distinguished guests. Mr. Pratap, a erudite lawyer and distinguished arbitration expert, has talked about primacy of arbitration over litigation. He has rightly pointed out that arbitration is superior to litigation. Some of the reasons given by him were it's much more efficient because it's not only fast, but it has got limited appeal. It can be appealed against very limited grounds of appeal. The proceedings, secondly, the proceedings are confidential, hence preferred by the business houses. This is very important. And the most important thing is that it is recognized internationally. Any award given by a court of law in India will have difficulty in getting its recognition internationally, but this arbitration awards are recognized internationally and it can be enforced. He also pointed out that despite difficulties in arbitration, the arbitration has got great potential and future. I'm in full agreement with him and endorse his views completely. I would like to start by drawing an analogy with arbitration versus litigation and electric vehicle versus commercial versus conventional car, that is using internal combustion engine. Everybody is aware that the electrical vehicle is superior to conventional cars, low in maintenance, low in noise, and above all, zero pollution, especially relevant with AQI touching 450 in Delhi. Now the question is, despite its superiority, why EV is a laggard? The reasons are that high cost and absence of infrastructure, basically charging infrastructure. The high cost, the high cost is basically due to the government policies. High import duties on components, high excise duty, and the third reason is that competing with established players is very difficult in the market. That means internal combustion engine manufacturers. What is required is an affirmative action to encourage by providing better charging infrastructure and tax benefits, and to restrict the use of common CO2, noxious oxide, and PM2 2.5 belching vehicles through the disincentives. To continue the analogy, government has to take affirmative action to by say legislating that all commercial contracts should have arbitration clause. Even if there is no clause, the dispute, if any, must be settled through arbitration only. The government has been doing a lot. There has been amendment in the Insurance Arbitration Act, and there has been not one, there have been several amendments. First of all, 1996, the entire act was amended, and there has been various amendments which is coming, and it is continuing on. So these all, we call it an affirmative action by the government to encourage arbitration. One of the primary advantages of arbitration is that arbitrators can be experts in the field, which is the subject matter of dispute. For an engineering contract between principals and the contractor, the arbitrators can be an engineer who understands the intricacies of the contract. In case of insurance contracts, an insurance expert can be appointed for dispute resolution. The insurance person is in much better position to understand the subtleties of insurance contract. A senior retired judge may have phenomenal knowledge on law of contract, principles of torts, laws of evidence, etc. However, he may not be aware of subtleties such as principles of indemnity, subrogation and contribution, rules of proximate cause. These are the things which only insurance people know very well. Another advantage of insurance expert is that he is not clouded by the nitty-gritties of Evidence Act and is guided by basic principles of insurance to decide the arbitral award. To conclude, I reiterate that arbitration is far superior to litigation for settlement of commercial disputes. The government is changing laws to make arbitration more acceptable as ADR, but a little more push is required. To carry on the analogy further with EV and commercial vehicle, can we think of driving a vehicle to, say, Nainital if there is no petrol pumps on the way? Imagine how much fuel we will have to carry. We are able to do so because infrastructure development during the last 100 years for the internal combustion engine is already there. In fact, if EV infrastructure is much easier to build, as every city and village has got electricity, and just we have to develop a tapping point. Unlike petrol, diesel, which has to be transported from hundreds of miles and stored in underground tanks. Moreover, every house has electricity, or so charging is no issue. If the team of insurance experts, if we have a team of insurance experts and the infrastructure of who are trained as arbitrators, we will have an infrastructure will be built for settlement of disputes, and it will be much easier to do it. And finally, kudos to Asian Center of Dispute Resolution for providing human service for building up this infrastructure of arbitration. Thank you very much.
Thank you, sir. Thank you so much for your words of wisdom. Before I introduce Shri Sanjay Joshi ji, I would request that all the participants and the attendees of this webinar to raise your questions on the chat so that it will be discussed in the open house session. Now it's a great honor for me to introduce Shri Sanjay Joshi ji, a very charming and energetic personality. And he's a postgraduate in environmental science with the postgraduate diploma in marketing management and a fellow of Insurance Institute of India. He hails from pristine state of Uttarakhand. Joined United India Insurance Company as a direct recruit officer in 1989. In his career spanning 34 years, he has had a rich and varied experience across the length and breadth of the country. In his distinguished career, he has handled almost all the technical departments at various levels, possessing good communication and interpersonal skill. He has had a long and successful stint as branch divisional heads and across various regional offices. He worked in large corporate cell at Delhi and in assignments at business offices. He has successfully dealt with all big clients, THDC, DSMA Group, TCS and Magma Leasing, BAIL and IOACL. His diverse experience and across multi-functions since his joining in the health department head office in October 2017 as chief manager. On promotion as deputy general manager, he came to Chandigarh regional office to head that. And I had very fond memories of witnessing him both dealing with internal customers as well as external customer. Very efficient and very, having a very positive attitude, always helpful to others. I invite Shri Sanjay Joshi ji to talk about on the topic of insurance dispute resolutions. Joshi sir.
Thank you, sir. Thank you, Amandeep ji, for this beautiful introduction. Respected chairperson for this webinar, Mr. Yogesh Lohia, ex-CMD GIC, Masood Wahab Sahab, Secretary General, ACDR, Mr. Arif Hoda, former CMD, United India Insurance Company, Mr. JP Singh, Secretary General, Madhyam, and other distinguished participants of this seminar. Thanks for giving me this opportunity of sharing my experiences as a general manager. Earlier, I have handled I have worked as chief grievance officer of the company, and also I'm currently I'm heading the corporate legal vertical of our company. So thanks for giving me opportunity to share my thoughts on insurance dispute resolution by insurance companies. First question comes to mind is why this insurance dispute resolution is necessary, and why any insurance company should consider it important. So recently we were approached by Ministry of Consumer Affairs, and they shared us the data that out of all the consumer cases pending in the courts, 1.69 lakhs. This data is from November 2022. So out of all the consumer cases, 1.69 lakhs consumer cases came from insurance industry, while from banking sector, which has a larger presence in the economy, the number of complaints pending were 70,000 only. So there's a huge difference of 1 lakh cases. So the first thought comes to mind: what is the reason for more consumer disputes in general insurance industry or insurance industry? So first of all, it's the nature of the contract. Here, a promise is sold to the customer, and year after year the policy is renewed, and very rarely incidents of claim happens. And when it happens, then suddenly something which is taken for granted, when it doesn't happen, the customer feels disillusioned or cheated, and then a sense of this dissatisfaction comes in, which leads to a dispute. Because the expectation of the insured, another reason is beyond this honoring of promise, the one dispute can be regarding the amount settled. The expectation of the insured and what is paid by the insurer often differs, and this leads to some disenchantment. Fine print of the policies, which is generally pointed out at such instances at this time of claim settlement, and lack of clarity on the product features is also one of the reasons for creating this discontent. Another problem is the archaic language used in the insurance policies. It is the 19th century English is still being used there, which makes it difficult for any customer to understand the clauses. Ideally, all the products should keep on being revised, but sadly, in lots of cases, we find that the products are not revised despite many years passing by. So non-revision of products is another issue, and that non-revision in view of the judicial interpretations, that is more important. So even if there is a judicially accepted principle, still the policies carry the earlier notions. Then another reason for not actually appreciating the policy conditions is because the common man lack in understanding of special features of insurance like proximate cause, insurable interest, and utmost good faith. Leave aside common men. In many cases, even the judicial authorities are found to be less than understanding on these points. So, in case a repudiation happens, this comes as a shock, and what is made more murkier by entry of this professional claim consultants and brokers. So even a simple dispute is turned into a very, very complicated thing. And sometimes where there is no dispute at all, if a professional consultant is hired from the beginning, he will make it sure that a dispute arises. So and one beyond this policy related matters and beyond the understanding part on the part of the insured, another thing is the quality of the surveyor and his report, whether he did his job thoroughly and professionally or not, and what was the process of conducting survey, how timely it happened. It can actually lead to a lot of frictions or lack of frictions, depending on the surveyor. So all these reasons are there which can lead to a dispute. And what are the choices available for consumer in case of such disputes is I'll discuss them one by one. So the first and foremost method which is available to a customer and which should in my opinion should be the first recourse is the internal grievance redressal mechanism of insurers. Not only insurers but also IRDAI, Insurance Regulatory Authority, and also the Ministry of Consumer Affairs. So all these bodies have come together and they have developed portals. So by statute, it is mandatory for every insurance companies to give this link on their websites where this customer can easily register his grievance regarding any perceived lack of services or unprofessional services or any sort of grievance. He can easily register there, and it is not only monitored by the insurance company, but it is also monitored by the regulator as well as by the ministry. So it is the best course, and the response has to be timely. What are the pros of this process? It is a time-bound disposal, since insurers are duty-bound to maintain and submit the statistics, and it is monitored by IRDAI also. And even the quarterly reports are to be submitted to the subcommittee of the board of directors of the company also. So in such cases, there is no need of submitting supporting documents because the insurance file, the claim files are already available with the insurers. And if the insurance companies' grievance redressal officers are serious about their jobs or they're sincere about their jobs and they are responsive, then the disputes are generally resolved very fast. And even in the internal processes of the company also, say the grievance redressal committees are given special powers. So their decisions are binding on the claim settlers also. So this benefits. So if the GRO decides in favor of the insured, then it can benefit customers hugely. Routine matters such as refunds, renewal notices, policy copies, ID cards, delay in survey, interpersonal issues with the surveyors, etc., can get resolved very easily through this mechanism, and that too without any cost to the insured. Even a delayed matter also can be resolved there if there are merits. So, what are the cons of this process? What are the drawbacks of this, or what are the weaknesses in this system? Is key. Generally, there is a tendency to maintain the decision, and certain organizational bias is generally there, and it is also because when you respond to the ministry portal, etc., then you have to just say whether the dispute is resolved or not resolved. So whether it is to the satisfaction of the customer or not, it is not known. But these problems can be. One more thing is that because there is a timeline, so there is a tendency to close the grievances very quickly, and sometimes decision can be again just to maintain the timeline. They can say, no, our decision was correct, and but these actually biases are now organizations, particularly like I'm telling from my experience, that even the insurance companies are very, very aware of these facts, and generally now there is an attempt to post most suitable officers in the grievance redressal departments of the companies, and particularly at every regional level and head office level, the most considerate and knowledgeable people are posted to handle these matters responsibly, because they are not only responding to customers, but also to regulatory bodies and as well as to the government, and we have to ultimately we are answerable to the board also. So we give it a lot of with a serious approach only. We are maintaining these departments. So solutions for the problems are that like I mentioned, by a judicious selection of grievance redressal officers, and they should be technically sound, and root cause analysis of the repeated grievances also should be maintained, and which we have done in many cases. And this root cause analysis ultimately leads to improvement in procedures. So, for example, we found that most of the grievances arise because of the ambiguous wordings in the policies. So accordingly, in the immediate revisions, all these ambiguities were removed, and to the extent possible, the policies were made unambiguous and very simple in wordings also, so that a layman can understand those. And similarly, system processes also are improved based on the root cause analysis. And if one particular condition is leading to repeated disputes, or some legal verdict binding verdict has already been announced by the higher courts, so generally we remove such restrictive clauses from the policies. So after I feel that this is the internal grievance redressal mechanism should be the first choice of any customer, and it leads to. I was very happy to note that in the survey conducted by the institute, many of the customers they expressed their satisfaction with the grievance redressal procedure, and most of them said they received a satisfactory response after this procedure was adopted. After that, the next best mechanism for any consumer should be the ombudsman. So insurance ombudsmen are posted across the country in different zones, and this ombudsman mechanism, is also very cost effective, but insured has to file in a prescribed manner and has to give supporting documents here. Ombudsman can also call for additional documents. This is a quasi-judicial process, and this process goes on. But awards will get implemented quickly since it is binding on insurers, and there is no recourse for appeal. And they have to also report this compliance status to the authorities, to respect even to the board. So generally, even the ministry, particularly for us, and the regulator, they are also very particular about the compliance to the ombudsman awards. But the limitation for this ombudsman mechanism is that only personal lines of insurances can be taken up there, including the sole proprietors, and the commercial bodies, they cannot approach them. Ombudsman can consider complaints on a wide variety of allegations or deficiency in performance of an insurer, agent, intermediary, and including brokers. But insured has first to, they should first approach the insurance company or the broker for their response, and only after that they can approach the ombudsman. The limitation is that ombudsman can mediate only. Generally, award is based on the pleadings and evidence, and compensation cannot go beyond indemnity. There is no damages, no punitive amounts, etc. But they can grant interest. Generally, insurers do not challenge ombudsman awards, and they satisfy because there is no provision for an appeal. But if it is totally beyond the policy, or if it exceeds the power of the ombudsman, or order is perverse, and then in many cases insurers may file a writ petition in high courts, and if it gets stayed, then the whole resolution may take time. Here I wish to mention that in many cases, the insurance ombudsman appointed are from the fields beyond insurance. Though to some extent it helps in removing the organizational bias, but on the other hand, when the ombudsman doesn't understand even the basic principles of insurance, and goes according to his own limited understanding or based on his whims and fancies. I remember one incident in Kerala where the ombudsman took upon himself and was visiting the insured's houses and doing some sort of investigation on his own, and then giving very fancy awards. And all such instances, because the process was totally violated and exceeded, and he was exceeding his brief in repeated. So lots of writ petitions were filed in Kerala High Court by the insurance company, and ultimately, so this cannot go on. You cannot say, okay, though insurance company is right in following this condition for repudiation, but the customer still requires some relief. So why don't you pay 50% of the amount? So this type of orders, and it is not only limited to the people who are new to insurance, but experienced insurance professionals who retired after service of 34, 35 years from the highest posts. They have passed such awards. In that event, the insurance company doesn't have any other option but to challenge these awards through writ petitions. So now coming to arbitration, which should be the maximum interest of all the participants. Here, I wish to mention that arbitrations, actually, these clauses were introduced, and they were intended with the laudable objectives of private dispute resolution mechanism or alternate dispute resolution mechanism. And it was a party-driven process taking the load off. The intention was to take the load off the judicial system. And they were meant to be speedy, cost-effective, fair, impartial, and high-quality awards were expected. But sadly, from our own experience, from the experience of an insurer, I say the reality is different. In the insurance contracts, mostly the quantum disputes were arbitrable. Denial or liability was an exception. Now, there was so much of misuse of this clause that now even the regulator, the Insurance Regulatory Development and Authority of India, Regulatory and Development Authority of India, IRDI, through its circular through a circular on 23rd October 2023, They have asked us to remove the arbitration clauses from all the policies issued under retail LOB. While in case of commercial policies, the parties are advised to have a independent clause. They can opt for a separate arbitration clause if they agree upon that, and it can be done at any time. So arbitration is no more compulsory. Personal lines, it is removed, and in commercial lines also, it is now subject to a separate agreement between the parties. It is not in an inbuilt part of the policy. When the clause was, when the clause was inbuilt, mostly the corporate insurers were invoking this, and outcomes have been very good for the commercial insured. Insurers have suffered a lot. Rarely did the individuals go there. Only the commercial companies were invoking it, and insurers suffered a lot. There were almost one-sided judgments by the arbitrators. This has been the government of experience, and this has been the experience of Government of India also, as apparent from a recent Government of India circular where they have also issued guidelines for removing of the arbitration clause. So whenever there is in what we had experienced, that whenever there is a giver and taker, give has generally been the trend in arbitration. And the general attitude was, if a person is asking for 10 crores, let us give him 12 crores. And if not 12 crores, at least 5 crores we should give. And that was the general trend. So this has resulted in the what was happening actually. The dispute is often a smaller issue. Suppose we have deducted some under insurance from the claim. So the dispute was for that only. But the arbitrator brought in new issues like, no, why are you deducting depreciation? And no, the surveyor has been unfair, and the rates are incorrect, salvage valuation is wrong, and interest for delay is also added. So the more and more issues are added, and then a very high award is generally awarded. And with professional firms taking over, the battle has even been more intense and long drawn than court battles. Interest granted were also bordering on 15 to 18%, which is very high. And pending the litigation, the interest getting added, the trend had been that pending litigation interest is also getting added. Post-award interest runs into on the whole sum. So we have seen awards completely ignoring the concept of depreciation or sum insured, and also awards granting interest for delay in claim disbursement only, since no other head was available to award. And the end result has been that the most awards end up getting challenged under Section 34 and 37, and ultimately lands up at the Supreme Court. Though the scope of interference is still limited, our experience is that even a reduction of interest from 15 to 12% or 9% by Supreme Court gives us a big relief. So the tendency has been to challenge such. I remember one example from Surya Udyog of Odisha, where heavy interest was granted by the arbitrator, and ultimately, even when the Supreme Court gave a limited relief through interest, still we saved crores of rupees. So it gives a reason for insurance companies to approach. So basically, a good, well-intended thought, because of the excesses done by the unscrupulous arbitrators, and sadly, many of the whom were actually from the insurance industry itself. This useful procedure actually has ended up earning a bad name, and litigation, instead of getting reduced, is rather increasing. So also, insurers usually deny the invocation out of fear of invariably adverse outcome, and by arguing that dispute is non-arbitrable or on the grounds of full and final discharge. Then insured then goes on to the court, and that gets the arbitrator appointed, and ad hoc arbitrations have been the norm, nor institutional arbitration is not in vogue at present. And generally, insurance companies have been preferring court-appointed sole arbitrators. The ever-changing precedents on law of arbitration and interpretation of the provisions of Arbitration and Conciliation Act and scope of challenge, etc., makes it difficult for officers to keep pace. So, particularly in the last 1 year, because of these excesses which I have mentioned earlier, the courts have also been awake to all these problems, and they have given a lot of relief, and that grounds of appeal have been expanded for the insurers. And I hope that the new act, which is going to be presented to the parliament very soon, it will be bringing in some clarity on the matter. So delay in conclusion of arbitral proceedings have been noted, and fees of both arbitrators and advocates went much beyond the budgeted amounts and scheduled fees. The interest meter runs during the delay in arbitration proceedings, and that also gets put on insurer only. So, and commensurate with the stature of the arbitrators, the infra and venue costs have also been expensive. So I note that in many of the cases, the fees of arbitrators as well as the advocates is ending up in crores. And that was one of the reasons that this lack of control over the fees and lack of control on the time. This was one of the reasons that insurance companies started shying away from all these procedures, and they were seeking relief elsewhere. And arbitral awards are not published, and their quality also does not come up for public scrutiny unless challenged in courts. And if challenged by insurers, and then it goes for years together altogether. So obviously, one party feels totally broadsided, and one party is the insurers, and they will keep on fighting on. And getting an award executed is also quite a task for the insurer. So these are the some of the drawbacks of this arbitration procedure, which from an insurer's point of view, I shared with you. Other than the arbitrations, there are other means coming up like permanent local adalats. These are also quasi-judicial authorities, but they have a pecuniary jurisdiction up to 1 crore. They are also very useful forum for insured, but not widespread in all states and still underway in many districts. Here also insurer cannot find appeal, and the only remedy for us is a writ petition. And domain experts are also members, and hit rate is very high for the insureds because it is very difficult to find competent advocates for us to appear in the smaller venues. So, but it is not as yet very popular because it has not been set up in every place. So, after all this only, we come to judicial bodies and consumer commissions and commercial courts. And because the important difference here is that there is a cogent reason or non-arbitrary. If there is a cogent survey report, if the surveyor has done his job very well, and insurer's decision is based on that surveyor report, and then it is very difficult for any insured to show any cause for deficiency in service in consumer commission. So in commercial courts, insured can subject a survey report to a forensic analysis, but in consumer commission, survey report is prima facie binding, and insured cannot subject to it to an in-depth attack unless he shows that there is that the survey report is arbitrary or based on irrelevant material. Similarly, if there is a well-reasoned letter of repudiation or letter of settlement, it is difficult for insured to win in a consumer commission. But in commercial courts, insured can bring in his full-fledged attack on the process itself and submit the surveyor to a detailed cross-examination. So consumer commission have come with arrest powers. Compensation can include damages also low. It is a low-cost procedure. And because it is based on the amount of premium charged, and there is no need to go to the higher courts. So I think that in the matters of consumer commission, the initial advantage is with the customer. But if the company feels that they are actually, if the survey report is good, if the letter of repudiation or the letter of settlement is good, then insurance companies generally defend themselves well. And if any unjustified order is there from the lower court, they go with full force to defend it. And of late, with very encouraging results have come. In NCDRC, the recent trend of insurers winning high-stake matters by engaging top seniors, you can observe that trend. We recently won a very big case from Supreme Court, where even NCDRC had gone against us. A very big case was won because we engaged the topmost lawyers, and we could establish that the survey report was very. It was based on cogent reasons. It was well reasoned. Lastly, I will like to give a brief mention of commercial courts. These are civil courts dedicated to commercial matters. Ease of doing business is there. Case management schedules are US type. They are like classical civil courts, but with strict deadlines for each step. So these may be the courts of future, and the video conferencing of the witnesses is allowed. Court fees are a bit higher, unless capped in some states. And there's compulsory pre-litigation mediation also. Amount in dispute must be 3 lakhs and above. And results will be very faster than the consumer commission. And we have seen that our attitude, we have found that mostly the commercial court degrees are respected, and we respect them because generally the quality of award is good. Quality of reward is quality of award is high, and in such cases we do not go for disputing them. So if after seeing all these possible mechanisms, I still feel that the first two, that is internal grievance mechanisms of the insurance companies and the ombudsman mechanism are doing great in terms of resolution of disputes for insurers. And insurers are actually also want to support these two mechanisms, and they want to bring more efficiencies to those mechanisms so that lesser and lesser cases reach there. Arbitration, which was meant to be a very good mechanism for alternate dispute resolution, can still be there. And I hope with all the flaws which I have mentioned there and identified, and the wise people are actually discussing on that, I hope that arbitration will also appear to be the third best dispute resolution. And with that, I sum up my case. Thank you. Thank you very much.
Thank you so much, Sanjay sir. Thank you for your inputs and a very practical approach. You rightly said that they nip the evil in the bud. I mean, it's good to hear that there are improvements being made in grievance redressal mechanism of the insurers. Thank you so much for being with us today and sharing your thoughts and the practical aspects of the dispute resolution. Thank you, sir. It's a great honor now for me to invite Shri JP Singh, Senior Advocate. He is having more than 43 years of experience. He did his law from Delhi Campus University in 1981 and elevated to the rank of to the designated senior advocate since March 2008. He's a well-known civil and commercial arbitration lawyer. He is also an accomplished mediator, and he is founder, organizing secretary of Samadhan, Delhi High Court Mediation and Conciliation Center. He has also received his training in India and also abroad in USA, where he has undergone training of trainers program and a part of training programs for mediators held within India and abroad. He has been appointed by the Mediation and Conciliation Project Committee of the Supreme Court as an observer of several training programs. He was associated with several workshops and given lectures on various subjects organized by several organizations and institution. He's also the Secretary General of Madhyam, International Council for Conflict Resolution, and remained Vice President of Delhi High Court Bar Association. It's indeed a privilege for us to hear Shri J.P. Singh sir, a very distinguished mediator. And as we all know that mediation is coming in big way in all commercial litigations, Commercial Courts Act, Consumer Forum Act, and Consumer Protection Act. So sir's talk would be very, very, having a, would be a great learning experience for us. And he will be talking of the institutional arbitration in India. Welcome, sir. Welcome.
Thank you, Amandeep. Thank you, all the dignitaries present here, and thank you for inviting me. First of all, the most important aspect, why arbitration? Because the reason was access to justice and speedy dispute resolution. One of the reasons why today arbitration needs to pull up its socks is also because of ease of doing business. The government of India is very clear that in case if you have to invite investment into the country, then the dispute resolution process has to be expedited and also need to be less expensive. ADR movement was promoted in the 1970s in the USA as a pragmatic search for resolution of what was defined as litigation explosion. Now, so far as India is concerned, we had arbitration, which was part of Civil Procedure Code 1908 before promulgation of Arbitration Act 1940. And now we have currently Arbitration Act 1996. A lot has been said already by Mr. Joshi on delays and costs. I like to just quote what Justice Desai, a former judge of the Supreme Court of India, in the matter of Guru Nanak Foundation in 1981 said. He says, interminable, time-consuming, complex, and expensive court procedures impelled jurists to search for an alternative forum, less formal, more effective, and speedy for resolution of disputes, avoiding procedural claptrap, and this led them to the Arbitration Act 1940. However, the way in which proceedings under the Act are conducted, and without an exception challenged in courts, has made lawyers laugh and legal philosophers weep. Experience shows, and law reports been ample testimony, that proceedings under the Act have become highly technical, accompanied by unending prolixity at every stage, providing a legal trap to the unwary. Informal forum chosen by the parties for expeditious disposal of their disputes has, by the decision of the courts, been clothed with legalese of unforeseeable complexity. Now, this was in 1981. We are today in 2024. Delays and costs. Justice H.C. Gupta of the Supreme Court, a former judge of the Supreme Court, talks about delays. Section 11, appointment, takes years. Challenge to the award, Section 34, takes years. Appeal from Section 34, Section 37, takes years. And finally, the matter lands up in Supreme Court. Mr. Joshi said, employing expert lawyers. And today, I don't think every expert lawyer or very experienced lawyer is within the reach of a common man. Why have we been practicing ad hoc arbitrations? See, most of our problem is drafting of the arbitration clause. In most of the agreements, what the clause says is, in case of a dispute, the parties will be referred to arbitration, and Arbitration Act and Arbitration and Conciliation Act 1996 will apply. Now, there is no way that you can have a unilateral appointment, which means you go back to the court and get an arbitrator appointed. And ordinarily, it is a retired judge. It was talked about domain knowledge also. Does a judge always have the entire expertise or domain knowledge of the subject, especially when we are talking about insurance? See, we lack today credible arbitration institutions in the country. And the result is, in most contracts, the arbitration clause does not contain the mention of any such institutional arbitration or arbitrational institution. Now let's understand, first of all, what is institutional arbitration? Institutional arbitration is administered by an established arbitration institution, such as International Chamber of Commerce. You have London Court of International Arbitration. You have Singapore International Arbitration Center. We have now Delhi International Arbitration Center, set up recently in Delhi. Now, these institutions provide a set of rules and administrative framework and support services to handle the arbitration process from start to finish. While ad hoc arbitration, on the other hand, is not administered by any external body. Parties involved in the dispute themselves agree on the rules, procedural aspects, and arbitrators. Here, the arbitration process is managed directly by the parties or through the assistance of an agreed upon arbitrator. Why institutional arbitration? What is the advantage? Because an institutional arbitration has established framework and rules. Institutional arbitration offers a predefined set of rules. You can go to any organization, which is offering arbitration services. You can get their set of rules and guidelines, which ensures uniformity, efficiency, and clarity in the arbitration process. Institutions like ICC or SIAC, which I mentioned, have well-defined established procedures that govern how cases should proceed, which can be particularly helpful in ensuring a fair and predictable process. Then, secondly, you have administrative support. One of the main advantages of institutional arbitration is the support provided by the administrative body. The institution handles the logistics and administrative aspects of the arbitration, including appointment of arbitrators, because it has its own panel, managing hearings, and sometimes even enforcement of awards. Then, thirdly, it has neutrality because it has no concern with either of the bodies, and it has a good reputation. Arbitration institutions are often seen as neutral, objective, especially when a matter relates to cross-border disputes, because parties have to come into the country, where parties from different legal and cultural backgrounds are involved. The reputation of these institutions add a level of trust and credibility to the process. Then, fourthly, you have specialized expertise. Many of these arbitration institutions have panels of expert arbitrators in various fields, ranging from construction, finance, intellectual properties, and even it can be insurance. This ensures that the parties have access to the best qualified arbitrators for their specified dispute. Leave alone, the procedural bias or institutional bias. I think sometimes the requirement of having a person who understands the domain subject or the knowledge of what is being actually arbitrated upon or what is the dispute between the parties does help. Now, in an institutional arbitration, there is efficiency and streamlining. They will handle all the, in the procedural part, so there's less room for delays and process is more streamlined. There's higher degree of certainty and enforcement, as I said, and recognition become very, very important. Ad hoc arbitration also has its advantages because it is more flexible in the sense that the parties have greater control over the arbitration process, including choice of arbitrators and the procedural rules, making it highly adaptable to specific needs. It could be insurance and other matters. It's more cost effective since there is no administrative body and ad hoc arbitration is generally cheaper, particularly for disputes that do not require complexities handled by institutions. Now, unfortunately, ad hoc arbitration in our country has become highly, highly expensive. Most of the arbitrators who are retired judges would not go by the Schedule 4 of the Arbitration Act. And the fees is phenomenal. I'll talk about it a little later. About what a speaker said about ad hoc arbitrations which are happening in India. Now, which model to choose? Now, it depends on the nature of dispute. Complex international disputes, particularly those involving multiple jurisdictions, are often better suited for institutional arbitration due to the expertise and administrative support which these institutions provide. Then there is more control and flexibility if parties prefer greater control over the process and are comfortable managing the arbitration on their own. Ad hoc arbitration offers more flexibility. Well, when it comes to international considerations for a cross-border dispute, again, institutional arbitrations offer ease in enforcement, particularly in jurisdictions that respect the rules of well-established institutions. See, one of the problems about writing awards is even if you have a domain subject expert, he is not a lawyer. He does not have the legal background. So sometimes awards rendered may be very good on merit, but because of procedural issues and certain, terms that they may mention while writing an award, they land up in court and, sometimes get challenged on those grounds. So therefore, these institutional arbitrations actually streamline those awards. See, award is given by the arbitrator, but the language to see that whether it doesn't fall foul of the current law, all those aspects are taken care of by the arbitration institution. And therefore, there's less likelihood of the arbitration award being challenged. Now, to avoid these situations, you see, amendments have been brought into the Arbitration Act when we talk of delays and the cost. In 2015, the amendment was brought in to actually expedite the arbitration procedure in our country by formation of an Arbitration Council of India, but which has not seen the light of the day even today. You will find in order to come up these situations, 2024, there is a bill now actually presented, which is open to public scrutiny. Now, this is called the Arbitration and Conciliation Amendment Bill 2024. Now, the key amendments that are sought to be brought in. One, they're changing the definition of arbitral institution. Now, the definition now under the draft bill, is a body or organization that provides for conduct of arbitration proceedings under its aegis by an arbitral tribunal as per its own rules of procedure or as otherwise agreed to by the parties. So therefore, more powers are being given under the draft bill to the arbitral institutions, such as power to extend the time limit to issue an award, to order a reduction of arbitrators' fees where delay stems from arbitral tribunal, and to substitute arbitrators. Now, these powers currently vest exclusively with the court, and the result is the matters ultimately, instead of being arbitrated, land up in court. And those years spent in the court actually cause or add to the delays. Then you have time limits now being set up. 60-day time limit for disposing of application under Section 8. If the matter has to be referred for arbitration, timeline is now fixed. Within 60 days, you have to decide that. 30-day time limit has been fixed for an arbitral tribunal to dispose of jurisdictional objections as preliminary issue. 60-day time limit has been set for appeals under section 37(1). So after the award is at 34 is over, 37 in courts has been taking years. So now the new amendment bill seeks to reduce that particular delay. Actually, there is a move to have a hands-off approach so far as courts are concerned. And now this act, the bill of 2024 proposes reducing court intervention, even application for interim measures. The arbitrators are being given more time, more power. Speeding up the process of commencing arbitration proceedings. It is from the when does the arbitration proceeding commence? That also the definition has been now changed. They are bringing in the concept of what is a broad practice, availability of interim relief through emergency arbitrators. Obviously, this will be subject to finally the arbitrator who is appointed to modify or continue with that particular order or to set that order set aside. Now, all these proposals are there basically to ensure that there is minimum court intervention and the matters get resolved quickly. Now, so far as costs is concerned, I told you I'll refer to a speech given by somebody without naming him. Now, he says there is lack of confidence, professionalism in India. Rules are there, which mean rules for everything, be it cost, time. Even so, there are flaws, such as arbitrations are conducted in 5-star hotels. Mostly the arbitrations start in afternoon, then there is tea break, then there is lunch break, and then the matter goes on. And, there are 2 sets of fees to be paid, one before lunch and one after lunch. Lawyers have to leave early for their litigation. So there is no lawyer today who's actually just only practicing arbitration. And the Attorney General for India, in fact, actually has been now advocating an arbitration bar. So all these measures are ultimately, being put into place to ensure that the arbitration gets institutionalized and also becomes less cost effective. Now, we did talk of mediation, though it is not the subject matter of today's topic. Mediation can be looked at provided parties have proper training. And I'm really happy with the 2 words Mr. Sanjay Joshi talked about. If repudiation should be an exception, and quantum is the one which needs to be negotiated. If that is the spirit, now let me tell you how it works without taking too much of time. In an MSUT matter, we know that there is a standard provided under the Act as to how much should be the claim. The matter in court, let's say it is like, the claim amount which the party is entitled to or the family is entitled to is 20 lakhs. The matter in court will take years. The deceased left behind the widow with 2 minor children. Now, if this matter is negotiated, the woman is willing to settle the dispute, which the insurance company would ultimately pay 20 lakhs at 10 lakhs. Why? Because this 10 lakhs today, timely payment has more value to the widow than 20 lakhs after a few years and then appeal and then matter goes on. Why? Because for her, the children who are today minors, she needs that money. The bread earner has gone. She needs that money so that the children can be educated instead of becoming urchins. And tomorrow they become the support system for the widow. So for her, this 10 lakhs paid today has more value. What happens? She is willing to take 10 lakhs, which has more value for her, and the insurance company, which would have ultimately paid 20 lakhs, also saves. Now, this is why mediation works, and mediation has been successfully actually practiced abroad. Mr. Joshi referred to various statutes bringing in the concept of mediation. And for me, I think insurance companies also should undergo, the people in the insurance companies and people who handle insurance claims should undergo mediation training so that these disputes can be nipped in the bud. Instead of languishing in court, instead of relying on the Supreme Court all the time, instead of relying on the expert lawyers and paying money to the lawyers, because ultimately that money and the time which is spent in court can be utilized for the insurance company as well as the person affected to move on with their lives. So to my mind, yes, institutional arbitration is much better so far as present scenario is concerned, but it is high time that the insurance companies also should get trained and look at mediation as a very, very appropriate dispute resolution forum in future. Thank you.
Thank you so much, sir, for the insight you have given to us with the coming up proposed amendment of the Arbitration and Conciliation Act and establishment of arbitral institutions and the need thereof. Thank you so much for your words of wisdom. Now I invite Shri Yogesh Lohia, sir. In fact, we feel really blessed to have him with us today. Shri Yogesh Lohia ji has a wonderful career. He did his B.Tech in 1973 as production and industrial engineering. And for some time, he was with the Atlas Cycles, very prominent institution for the manufacturers of cycles. And thereafter, in 1977, he joined the Oriental Insurance Company and rose to become the youngest general manager in Oriental Insurance in 2002. In 2007, the government of India had picked him for the position of CMD of General Insurance Corporation of India. And he was designated as chairman of GIC Housing Finance Company and GIC Asset Management Company also. He served as a director member on the board of several insurer and reinsurers within India and abroad. He remained with ESGC, Asia Reinsurers as directors, and the National Insurance Academy, and Deputy President of President of Insurance Institute of India. He opened up in branches in London, Dubai, Kuala Lumpur, and obtained eventual reinsurer status in Brazil. And during his tenure, he became the 15th, GIC became the 15th largest reinsurance company in the world in 2011. And post-superannuation, Sir has joined IFCO Tokyo General Insurance Company as Managing Director and CEO. So he also remained with Trinity General Insurance Company. And he was appointed member of Expert Committee on Reinsurance from 2017 and member of Reinsurance Advisory Committee from 2018 by IRDAI. Asia Risk Transfer Solution, Singapore appointed on its board in 2018. And he was chairman of Insurance Committee of EST Chambers of Commerce and Industry, member of Insurance and Pension Committee of FICCI, and CII. He's a prolific writer and authored several books on various issues related to insurance sector and presented papers on a variety of subjects at seminars in India and abroad. And several of those have been awarded. We really feel blessed to have Shri Yogesh Lohia ji with us today. And I request him to give his keynote address, and then we will have the open house session. Shri Yogesh Lohia.
Mr. Amandeep Singh, it would be better that we, if Mr. Lohia permits, I feel we can take the questions. There are just 2 questions, so fine. So Lohia sir, if you permit, we'll take the questions and thereafter, sir. I mean, I hope I'm audible, sir. Your mic is off, sir. Your mic is still off, sir.
It's okay?
Yeah. Now you are audible, sir.
Yeah, you can go ahead. No
Yes,
doubt,
sir.
we only crossed the time. You can go ahead with this and
Mr. Was he had another conference and he had told us earlier also. So he has left, but we have Mr. Joshi, Mr. Arif, and we have Mr. Pratap also who has joined us because his case got adjourned, but he is joining us from his court premises, so he's not in a position to speak. So he's there, but he will not be able to speak. So I'll request the speakers to respond to the. Just one second. I'll request the speakers. We have two questions. One question is one question is from Mr. Sharma. He is a participant of Insurance Arbitration Certificate course. And his question is, what is the current situation regarding arbitration clause? This question is for Mr. Joshi.
Yes,
What is
yes.
what is the current situation regarding arbitration clause? Are we still using old wordings or it has been revised? Are PSUs designing new wordings?
Yes, sir.
I'm reading out this question because only participants or attendees are not exactly permitted to
Okay. Okay, sir.
speak
I
out the
got this
questions.
question.
So anyone else who wants to raise a
Namaskar,
question? Yeah. So you kindly, Joshi,
Yes,
Joshi sir,
Namaskar.
please.
Yes, sir. I can respond to that. Namaskar, Sharma ji. Sharma ji has been an old colleague, senior colleague in United India Insurance Company again, where we work together in Lucknow. So very nice to see you here, sir. The current situation is that we are actually complying with the IRDA regulations, and we have removed this clause from all our retail policies. Simultaneously, in all our commercial policies, we have introduced the mandated wordings from the IRDA, which say that the parties to this policy contract can separately enter into arbitration agreement if they wish. So this standard line is appearing on the policies which are being issued. So wherever this other party, other commercial insured is interested in having an arbitration agreement, that this agreement can be decided, the wording of that agreement can be decided mutually. We have already got some of the standard wordings from our side, and depending on the acceptance or the suggestions of the opposite party, we agree or disagree. But such instances have been very rare. Only when some brokers are coming on with this request, then only. And it is not essential that these agreements are signed at the time of issuance of policy itself. This arbitration can be separate arbitration agreement for commercial lines of business, commercial clients can be entered into at any stage, even after the issue of the policy, before the claim or at the time of claim also. So that there is no time. The regulation just says you can have a separate agreement. They have not given any time length when you can have this. So it is a much more enabling. But of late, I am not aware of many parties coming in for that. So to conclude, no arbitration clause in the policy retail policies, and in the commercial policies, we are writing what IRD has mandated in their circular, that separate agreements can be done. And then it depends on case-to-case basis. Thank you.
The second question is from Mr. Narsimhan. He's asking Mr. Joshi, currently the limit of claim to be handled by Ombudsman is rupees 50 lakhs. Removing of arbitration from retail policy has limited individual having claim over rupees 50 lakhs, as they have no choice but to approach consumer courts only. Today, we have in health policy with upper limit of rupees 1 crore and over. Should this not be remedied by bringing back arbitration retail policy also? I hope you have got the question.
Yes, sir. Yes, sir. So I agree that there is a logic here. So either it can be brought back to individual, but otherwise also, when this clause was there in retail policies, we seldom saw any request for arbitration coming for retail policies. So though the provision was there, it was never invoked. So mostly this clause was being utilized by the commercial firms only. And in any case, alternative other than this bringing back the arbitration clause, the alternative can be that the ombudsman power can be increased for this. So I particularly, I'm a bit biased against introducing arbitration back in retail policies because of the blatant misuse being seen in the previous days and how it actually increases to the burden of the insurers and actually provides provides an occupation to the retirees from the insurance industry mainly. So if this misuse is curbed through the new mechanism or the new legislative act, then maybe then companies themselves will be agreeable to this. So if the spirit of that clause, arbitration clause, which was to quickly dispose disputes at a low cost in a very short time, if that spirit is brought back, then this can be considered.
Thank you. Thank you, Joshi sir. There were just 2 questions, and because of the paucity of time, questions. So thank you very much. And I'll now request Lohia sir to kindly take over, sir.
Today's session, I mean, a lot of new interpretations have come, and especially more so, Mr. Singh, Mr. JP Singh's on institutional arbitration is a very informative information, and Masood should look after this approach of putting institutional arbitration through the academy. I want just to share some of the thoughts that no doubt Mr. Pratap has mentioned that by 2021, there were 3.5 crore cases pending. Just I would like to correct it that by 2024, it has gone to 4.5 crore. I mean, just a total court judges of 20,000, 22,000 in India, how they can manage the disputes or the cases in a fast manner. So there is various alternative available. Arbitration is one of the alternative available to sort out the cases. And if you go by the monstrous pendency of the cases of 4.5 crore, and it is quite interesting so far India is concerned that we are having only 20 judges per million population. I mean, 20 judges just for 1 million population. So the target is that by 2000, another 5 years, they should touch 50 judges per million population, which is next to impossible so far as Indian conditions are concerned. That's why this need has come for arbitration to be expedited and to adopt it. It provides quick redressal to commercial dispute by private arbitration. Quick decision of any commercial dispute is necessary for smooth functioning of business and industry. International market do adopt into arbitration than a judicial system. In India, due to this heavy burden of monstrous 2.5 crore cases pending, and this arbitration is the only solution to expedite the issues. As I said, that arbitration is quite not expensive, but if you go by Mr. Singh, that if senior judges are adopted and they go for five-star hotels and lunches, then it becomes expensive. But if you go by institutional arbitration, it is not that expensive. Lots of organizations wound up their business because of cost involved, and especially MSME and low class of organizations. So one can imagine that it leads to some mechanism through arbitration to sort out the matter. Arbitration is definitely an efficient and effective dispute resolution mechanism critical to Indian business, foreign investment in India, the Indian economy, and the rule of law. According to survey, over 80% of the people or 80% of the organization, they prefer to go for arbitration for expediting decision. And even out of this 40%, out of 80%, the 40% people, they look into arbitration judgment within 30 days. And of course, the arbitration clause goes by that procedure. In arbitration disputes, as mentioned, parties try to resolve their dispute conflict behind the closed door, and it is considered to be a confidential one and is not subject to public domain also. That's why the preference goes to arbitration. And of course, it's a time-tested and time-saving dispute solution and not subject to public scrutiny or press scrutiny, and hence it has become more confidential. So this is what I wanted to share, but of course, all speakers have spoken to the best of their knowledge, best of the experience. But for me, it was a good lecture so far as Mr. Singh is concerned on institutional arbitration and the benefits and the various observations made by various judges, retired judges, has made us think that arbitration institution, which leads to a lot of experts, professional, and various other types of people available in the institution, which can go for economics, so far as insurers or any corporate office is concerned. This is what some of the thoughts I thought let me share with you. And thank you very much. I think all speakers must given the best of their knowledge, experience to the participant. Thank you so much.
Thank you so much, sir. Thank you. We really are happy that you are always there whenever we call you and shower your blessings on us. Thank you so much, sir. With this, any question if the participants would like to ask?
Amandeep sir, we will not be able to take any more questions.
Okay.
We have exceeded the time and we started. So we will now go on to the next session. The highlight of today's webinar, and with permission from Mr. Amandeep Singh and Mr. Lohia, I'd like to coordinate the second session. The second session is the investiture and valediction of the insurance arbitration certificate course 6th batch. We have 20 people in this batch. Amandeep Saab, I hope they're all there. Amandeep sir? All of them are there, I hope.
I'm sure all are there, but I will again check.
Just, yeah. Because those who are missing, they will not be able to say they are missing. So we have Satinder Sahib is also there. He will be. And of course, Mr. Joshi, he will be chairing the session. So, first of all, we'll be requesting some of the participants to speak, just for a very short while of the experience of this course and uh, how they find it and what learnings they are taking back. We have chosen 4 persons from this group of 20 to speak because this group, this whole batch was divided into 4 groups: a Bottomary group, a Hammurabi group, a Pharaoh group, and a Respondentia group. Now, those who are from the insurance industry relate to these words. These words have been used in the insurance sector while talking about the history of insurance. So this is not the time to go into the definition of Bottomary or Hammurabi, but just suffices to say that we have these 4 groups. And from group Bottomary, inviting Mr. Anish Jacob. Mr. Anish Jacob, I hope you are there. If you can switch on your, yeah. So if you can switch on your this thing, right? So we
Yes,
can
I am
see
here.
you. Now, Mr. Anish Jacob is a veteran of he at present is an insurance consultant, and he has worked mostly in South Africa for quite some time. So I'll request him to, speak on behalf of his group, that is Bhattabari. Yeah, Mr.
Thank you, sir.
Anisha.
Thank you, sir. Good afternoon, respected guests, esteemed teachers, fellow students, and dear friends. It's an incredible honor to stand before you today on behalf of the Bottomry Group of 6th batch of Insurance Arbitration Program of AIRM. I've been fortunate enough to have worked in many insurance markets, and everywhere insurance arbitration is seen as a costly, time-consuming affair and the least preferred method for dispute resolution. This gets compounded by the existing arbitration clause in insurance policies, which is restricted to disputes on quantum only, and disputes on other issues, conditions, warranties, claim admissibility, etc., will have to be decided in a court of law. Going for insurance arbitration was seen as a measure of the last resort. So why did I join the program? My good friend Ragesh Narlaji, expert surveyor from Gujarat, had shared the course info. After seeing the curriculum plus the monumental changes happening in the legal ecosystem, it was thought worthwhile to enroll in the program. To my surprise, I found the course to be one of the most comprehensive and best I have attended. It gives one a 360-degree view of the entire field of insurance and law, including arbitration law, law of contracts, etc. As a result, our understanding of the arbitration process has changed exponentially for the better. Behind this successful understanding of the subject of arbitration, there has been the guiding hands of our incredible teachers and course coordinators. To name a few, Wahab ji, Amandeep Singh ji, Pradap ji, Vandana ji, Mallikarjun ji, Sen Sharma ji, Lohia ji, Kushbu ji, and many more luminaries of the insurance and legal fraternity from India and abroad. On behalf of all the students here, I would like to express our deepest gratitude to our teachers, our gurus, our mentors. As students of a wide age band, I think we are from 30 years to 65 plus. We have spent many hours together online, working on assignments, preparing for quizzes and mock arbitration. We also had a few imaginary online peers sitting in the charge. And now here we are, more knowledgeable, stronger, and much wiser. We now view insurance arbitration in a new light. As a business enabler, I know that expected changes in arbitration law can make the insurance market more customer friendly. As we now stand on a threshold of new beginnings, the road to arbitration do seem a little bit bumpy, but filled with endless possibilities. But we are prepared for all challenges as our teachers, our gurus have made us arbitration ready. To my fellow students, I say this: we will arbitrate, we will aim for win-win decisions for all parties who repose their trust in us, and we will make insurance greater. Thank you for being part of this journey. Congratulations to us all, and here is to the next chapter in our lives. Cheers.
Thank you. Thank you very much. I'll now be inviting Miss Annie. Jenny, Miss.
Yes, sir.
From the group Hammurabi.
Yes, sir.
Your mic is. Yes.
I hope you can hear and
Have
see.
we switched on you? Yeah. Okay.
Yes, sir. It is switched off.
Oh, okay. So just Ms. Jenny, she is a Deputy General Manager with the United India Insurance Company Limited, and she will be representing her group. So please carry on.
Yes, sir. So a very good afternoon to all. It's with immense joy and gratitude that I'm here today to speak on behalf of the Hammurabi Group. At the outset, I would like to extend my heartfelt thanks to the ASEAN Institute of Insurance and Risk Management for organizing this very enriching short-term course and giving us an opportunity to grow and to learn. When we started this journey, we knew it was short, but none of us could have anticipated how impactful it could be. Over the past 6 months, we have gained more than just knowledge. We have gained new skills, new perspectives, and these are going to stay with us forever. I would like to take a moment to appreciate the incredible efforts which our instructors, mentors, and the guest speakers, the speakers who were from India and from abroad. Their dedication, their expertise, and their complete involvement in this whole course has inspired us in every step during this journey. Our very special thanks to Shri Masood Wahab, Shri Amandeep sir, Ms. Vandana Kannan madam, and of course the Supreme Court Senior Counsel, Shri Pratap Venugopal, for ensuring that this program was well organized and for keeping it as a most engaging course. The very good part of this course was that it commenced with the basics of insurance, which was indeed helpful for all those participants who were not in the field of insurance or who were new to the field of insurance. All the sessions were interactive, giving ample scope for the participants to understand the principles better. The group presentation, the online quizzes, the multiple choice questions, etc., kept the participants involved in the whole process, and it gave room for many brainstorming sessions also. The final sessions, which dealt with arbitration functions, and the arbitration laws, were the highlight of this course. It gave an opportunity for all the group members in conducting mock arbitral sessions, preparation of arbitral awards. And we were fortunate to have experts like Shri Pratap Venugopal, who evaluated the awards which were prepared by the groups. And this evaluation was done in detail. The suggestions and the advice given by him and by the other experts made us understand the whole process of arbitration in a much better and practical way. As we conclude this course, let us remember that this is not the end, but it's a new beginning. The insights and the skills which we have gained here will empower us to face challenges and to seize opportunities in the new, emerging, and in the respective fields. Thank you all, and I wish everyone the very best in the future endeavors. Let us continue to learn, grow, and make a positive difference in the world. I also hope and pray that many more join the ASEAN Institute of Insurance and Risk Management and benefit from such well-designed and excellently executed course curriculum. Thank you all. I hope I was visible and audible because I don't see any reaction after that.
Thank you so much, ma'am. Thank you so much. I think Wahab sir somehow disconnected. Now I invite Mr. Neharanjan Wala to share his thoughts from Group Faro.
Uh, am I audible, sir?
Yes, yes, you are audible. You are visible.
Good afternoon. Good afternoon to today's chairperson, Sri Sanjay Joshi, sir. Good afternoon to all organizers, to all guests, and my fellow batchmates. At the outset, I would like to thank to Asian Center for Dispute Redressal, along with Asian Institute of Insurance and Risk Management, for giving me opportunity to be a part of this 6th batch of ISCC. After going through the 6-month course by various discussion, lecture, mock session, and various assignment, I do believe this course has been designed covering the both insurance aspect and legal aspect adequately, which is very useful for any arbitrator. And I would also like to inform that all the faculty from the abroad as well as India, they are very cordial throughout the course, very cordial, very knowledgeable, and caring to us. And in last 6-month period, we have enjoyed in learning, and it is our lifelong memory. And at this stage of life, such type of learning is just awesome. My group mates have cooperated, helped, and assisted all along. We have been good friends. It will give me dividend in future, giving full respect to all faculties. I intend to say some words about some faculties. First of all, I want to say a few words. My respected Satyendra sir, his way of lecture and his handling the so many sessions, it is very difficult to express. I want to say he is simply a super professor for this type of program. Now regarding Pratap sir is very, very energetic, is evergreen, and he was always caring for us. And his every session, his involvement has shown that this legal aspect has been designed by his total involvement. And regarding Amandeep sir, at the end of every day's session, Amandeep sir's comment is really very precise, informative, conclusive, and he has drawn the conclusion with a very, very sweet smile with sweet voice. That is very attractive and that is loved by everyone. And at the last, on behalf of my group Faro, I thank to all. This is a very, very memorable experience although after doing the very responsible duties in my profession in last 6 months in the evening, I have managed successfully, and I am grateful to all my gurus and teachers who have made me to complete this program successfully. And I am confident that all my batchmates will be performing well as arbitrator, as and when they have been appointed as arbitrator. Thank you, sir. Thank you.
Thank you, Mr. Nihar Bala. I forgot to introduce him that he is a serving Chief Regional Manager. Thank you very much. And I'll now be inviting the last speaker from the group, Ms. Varsha Gujarati. Ms. Varsha Gujarati is the Chief Claims Officer and Head Operations and Customer Experience with Universal Sompo General Insurance Company. You can switch on your camera.
Yes, sir.
Ms. Varsha, if you can.
Can you see me, sir?
Yeah.
Thank you very much.
Please.
Good afternoon, everyone. Respected dignitaries present here today and my dear fellow students. As we conclude this incredible arbitration course, I, on behalf of Respondentia Group, want to take this opportunity to reflect and express my deepest gratitude to all those who have contributed in making this entire 6 month experience so meaningful. First and foremost, my sincere thanks to ASEAN Institute of Insurance and Risk Management, the organizing institution. In fact, your commitment to creating this all well-rounded and impactful program has been great. It has been every step, it has been evident that it was highly professional and well conducted. The structure, the reading materials which were given, the depth of the topics all covered have far exceeded our expectations, and we are leaving behind, we are all taking with us very, very invaluable insights. To all the instructors, speakers, thank you so much for sharing the wealth of information, the knowledge, the practical experience, and especially your passion for arbitration, which has been so much contagious, I would say, to all of us. Each of you brought in diverse perspectives, which not only broadened our understanding of this entire field, but also inspired us how we could think critically, how we could think creatively, and the pointers given after every session were very to the point, and you will be surely useful to us when we practice. Your dedication and patience in answering all the questions, guiding us to the different complexity of arbitration is also highly appreciated. Your contributions have made it possible for us to assess and have such a high caliber learning opportunity. Special thanks for the mock sessions conducted, the case studies done, and the valuable points given, the corrective actions. What I observed was always the teachers were very motivating, though they had to give us some feedback. It was given in such a way that we are doing well and then we should do better. So that also kept inspiring us, a very nice way of teaching. Suggestions given always were very, very motivating. To Amandeep sir, to Wahab sir, Vandana madam, thank you very much for working tirelessly behind the scenes, taking sessions. Thank you for the support, the professionalism, efficiency with which you all have conducted this course, addressing technical issues in the beginning to training us how to use this Teams well for submissions of our homework, etc., to the smooth, enjoyable learning experience to all of us. Finally, to all my fellow participants, Respondentia group and other larger group, gratitude for all the engagement and diverse experiences, perspectives shared. And I'm sure it will build a sense of community amongst ourselves. Respondentia group is like family now, with all the multiple discussions that we have had and engaging discussions. So as we step forward, let's carry forward the skills, the knowledge that we have acquired, the values that we learned. And finally, to me, arbitration is not just a process. It is something that we commit ourselves to fairness, to justice, and that we will help in resolution of conflict with integrity. And I'm sure each of us will make a meaningful impact in whatever we pursue. Once again, thanks to everyone who made this such a rewarding and unforgettable experience, and wishing you all the very best in future. And I hope our paths cross again. So thank you very much. Thank you.
Thank you, Ms. Varsha. Thank you very much. And we will now be having the next session of oath taking. That is the arbitrator's oath taking. And for this, I'll be requesting Mr. Amandeep Singh he is the person who has both the qualification of insurance as well as law to administer the oath, arbitrators. So I will, first of all, both Mr. Satendra Sahab and Sanjay Sahab, I'm highlighting the people, those people who will be taking the oath. So I'll be, Mr. Amandeep Sahab, you'll be.
Sir.
One by one.
Thank you. Before we start with the oath ceremony, I just wanted to share that the grades and the consolidated result has been shared by me just now. with all the participants. And my heartiest congratulations to all the participants of sixth batch for having achieved the grades of A and A plus both. It's really you see an experience of mutual learning, and we really enjoyed your company for the last 6 months. We will begin with the oath ceremony. So first of all,
we will.
I invite Mr. Mahendra Kumar from Respondencia Group.
Mr.
Your camera and.
Sir, Mr. Mahendra Kumar is not there today.
Okay.
Okay,
Then,
next.
Mr. Susmeet Vora, sir. Vora, sir. Yeah. So start taking oath. I, Vora, sir.
I, Susmit Harshad Rai Vora, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understandings, so long as I hold that appointment. So help me God. Thank you.
Thank you, Vora, sir. Thank you for being certified insurance arbitrator. Now I invite Mr. Arun Kumar Bhatia ji. Mr. Bhatia.
Yeah, I am there, sir.
Yeah.
I, Arun Kumar Bhatia, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Nay.
Thank you. Thank you so much, Bhatia ji. Now I invite Mr. Ashok Kumar. Ashok ji.
हाँ मैं कसम खा के बताऊंगा.
Yeah,
मेरे पास
Amandeep
कितने
Sahib,
हैं?
I didn't get the name.
Mr. Ashok Kumar.
Yeah, Ashok Sahib.
Please unmute yourself. Unmute yourself.
You are muted, your mic, yeah.
You are muted,
We can't
sir.
hear you.
We can't hear you.
We can't hear you. We will try you again.
We will invite you again, sir. We will invite you again. Now I invite Mr. S. Srikant.
I, S. Shrikant, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Thank you, Srikant ji.
Thank you, sir. Thank you, sir.
Now I invite Madam Harsha Gujrati. Yeah.
I
Uh,
Yes, sir.
you're inviting, once again, I couldn't get you.
Madam
Next.
Rati. She is there.
Okay.
Yeah,
So
start it.
I, Varsha Gujarati, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Thank you, ma'am. Thank you. Now I invite Mr. Nihar Ranjan Bala. Mr. Nihar Ranjan Bala from Faro Group.
Yes, sir.
Yes.
I, Niharanjan Bala, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all duties incumbent upon me as an arbitrator, without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Thank you. Congratulations. And congratulations being the topper of this sixth batch.
Thank you, sir. Thank you.
Now I invite Mr. P.R. Raman. Okay, please. Raman, sir. Yeah.
I, Padua Sahasram Raghunathan Raman, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities and understanding, so long as I hold that appointment. So help me God.
Thank you, sir. Thank you. Congratulations. Now invite Mr. Narsiman, sir. R. Narsiman, sir. Yes, sir.
I, R. Narasimhan, do hereby solemnly affirm that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator, without fear or favor, affection or ill will, according to the best of my skills, ability, and understanding, so long as I hold that appointment. So help me God. Thank you.
Thank you, Narsiman, sir. Thank you so much. Now I invite Mr. Meher Ghosh Todiwala, sir.
I, Mehernosh Noshir Todiwala, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the
Meher
best
notes
of my
have
skill. G.
Your camera is not on.
Mr. Meher notes have kindly switch on your camera and take the oath again, please.
My camera is on.
I couldn't see. I mean, I'm not able to see you.
Now do you see me?
No,
My camera is on, sir, here.
You are not.
I can't see it.
From your side, I don't know. Switch camera.
Okay. I mean, you work on the camera. If it comes back, we'll have it. We'll have you back again.
Okay,
so next,
fine.
Next, Amandeep sir. Next.
I invite Shri Tondap, sir. Is there? Sir, I
do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, ability, and understanding, so long as I hold that appointment. So help me God.
Thank you. Thank you so much, sir. Now it's turn of Hammurabi Group. I invite Madam Jenny. Yes.
I, Jenny P. John, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God. Thank you.
Thank you, ma'am. Congratulations. Now I invite Shri Ravindra Bagaji. Shri Ravindra Baga. Yeah.
Am I visible and audible, sir?
Yes, yes, you are visible and audible both. Start. I,
Ravindra Bagga, do hereby solemnly affirm that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator, without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God. Thank you.
thank you, Bagaji. Now I invite Madam Pragna Joshi. Yes.
I, Pragna Joshi, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartial discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skill, ability, and understanding, so long and my hold that appointment, so
Hold that.
help me God.
Thank you, ma'am. Thank you so much. I believe Meherno sir is there. I invite Meherno sir. Yeah, start taking. Unmute yourself, sir. Unmute yourself. Yeah. I,
Mernosh Noshir Todiwala, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
thank you. Thank you so much, sir. Now I invite Mr. Vishnu Prasad Sharma from Hammurabi Group. Vishnu ji. Yeah, thank you.
I, Vishnu Prasad Sharma, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear, favor, affection, or ill will, according to the best of my skills, ability, and understanding, so long as I hold that appointment. So help me God. Thank you.
Thank you so much, Vishnu sir. Now it's turn of Patamri Group. I invite Mr. Ajesh Kumar Singla ji. Mr. Ajesh. Yeah. Sir, please switch on your camera and unmute yourself. Yes. Yeah, you are audible.
Yes. I, Ajesh Kumar Singla, do hereby solemnly swear or affirm that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God. Thanks. The order then, sir.
Now invite Shri Anish Jacob ji.
I, Anish Jacob, do hereby solemnly swear and affirm that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Thank you, Anish.
Thank you, sir.
Now I invite Madam Kavita Anand. Yes,
I, Kavita Anand, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator, without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me, universe. Thank you.
Thank you, ma'am. Thank you. Now I invite Mr. Ravi VP.
Yes, sir. Sir. Hello. Hello. Sir, am I audible?
Mr. Ravi, no, you're not visible.
Is it so, sir? 1 minute, 1 minute.
Can you switch?
Yeah, I'm on, sir. My camera and my yeah.
Audible and
Yeah, please.
Am I visible, sir?
Yeah.
Yeah. Okay, sir. I, Ravi VP, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear, in favor, affection, or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God. Thank you.
Thank you so much, Ravi sir.
Thank you, sir.
Now I invite Mr. Harshvardhan Chaudhary ji.
Yes, sir. I just one second, sir. I, Harshvardhan Chaudhary, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Thank you, Harshvardhan sir. Congratulations. I again invite Mr. Ashok Kumar to switch on his camera and take oath. Yes.
Yes, sir. Am I audible now, sir?
Yes, you are audible now. Yeah.
Thank you, sir. I, Ashok Kumar, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator, without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God. Thank you.
Thank you so much, Ashok ji. With this, all 19 arbitrators have today taken the oath.
No, sir. Mr. Ashish Damor is left. Ashish Damor.
Okay, Ashish ji, please, I invite you.
Is he there?
He is there, sir. He has put a message also on the chat line.
Okay, okay. Ashish, sir?
It is not, name is not appearing. Is it appearing?
Yeah, yeah. It is there, sir. It is there. Ashish, sir? Please switch on your camera. Probably I missed his name. Yeah.
Mr. Ashish. Mr. Ashish, we are waiting for you.
Please unmute yourself, sir, and switch on your camera.
The call. Hello.
Ashish ji?
Sahib is not able to unmute. So, okay, you do one thing, you ring up you have the number of Mr. Amandeep Singh? Huh?
Ashish ji, you can try on mobile.
Yeah, he is trying from mobile.
Yeah.
Okay.
Yeah.
One sec, then I have to answer this.
Yeah.
I, Ashish Bharat Singh Damo, do hereby solemnly swear that upon accepting the appointment as an arbitrator, I will faithfully and impartially discharge and perform all the duties incumbent upon me as an arbitrator, without fear or favor, affection or ill will, according to the best of my skills, abilities, and understanding, so long as I hold that appointment. So help me God.
Thank you, Ashish ji. Thank you. So with this, I believe all the participants.
It is complete?
Yeah, complete, sir. All 19 participants have present today. They have taken the oath, and they are designated as certified insurance.
Who was not present? Who was not present?
Only Mahendra Kumar from respondent chair group.
He has sent a message why he is not present.
He's not present, I believe. He's not attending. I think his batchmates.
There is no message from him. Anyone knows about his absence?
Mr. Mahendra is not attending classes since long. From first or after first or second class, he has left the course.
No. We were having 21 people, so there were 20 actually final.
Yeah.
I'll now request Mr. Joshi, Mr. Satyendra Singh to kindly switch on their cameras. And
yeah, 20 participants, they have taken the oath.
Yeah, 20 must have taken.
Yeah, 20 they have taken, sir.
So Mr. Mahendra sir, he was not well, sir. He was unwell. That's why he was not able to continue.
Okay. So 21 participants.
Satyendra sir, if you can switch on your camera, please. Joshi sir also.
I'm already there.
You come.
My camera is on and my mic is also on.
Amandeep sir. So, having taken the oath and declared their results, so all the 20 participants, excepting the one who couldn't do it, they're all now declared as certified arbitrators, certified insurance arbitrators. America, but of India. So they are now CIA, certified insurance arbitrators. And they will be offered to be on the panel of ASEAN Center for Dispute Resolution. And now, having heard the oath taking, I'll request Mr. Sanjay to give his blessings to them, his Ashirwad. Sanjay sir. आपका कैमरा फिर से
नहीं, actually I am able to see myself. Amandeep ji, am I visible?
Visible, sir. You are visible.
Yes, sir. Yes, sir. So,
my
congratulations. So my congratulations to all the successful candidates who completed this course. And as I can see that they are the best from the insurance fraternity and many from outside also. And those whom I already know, I know what quality they will bring to this new arbitrators, this group of arbitrators. And I'm very sure and confident that the quality of arbitration will actually go better and better with such conscientious, honest, competent people joining in this group. And I compliment the institute also, ACDR, for engaging in this noble pursuit. And see, when any institution, when it develops, it goes through various ups and downs, and we constantly keep on learning, keep on learning from the process and keep on improving it. So, but it is a fact that ultimately we cannot afford to have so much of litigation, and every possible means for avoiding litigation should be actually encouraged. And it may have temporary up or down, but ultimately it is assured that arbitration will be much sought after mechanism for resolving issues out of court. I was going through this oath taking ceremony, and if every participant actually goes by this oath and they remember this oath and this impartiality and competence is reflected in the judgments, then there is no reason why any party will oppose it or not welcome that. So my best wishes to the new arbitrators. And hopefully we will be engaged from the various institutions like us, and both as institutional arbitrators as well as individual arbitrators, they will be much sought after. So my best wishes for them. From the side of insurers, I just want to say one thing, that our motto is avoid all avoidable litigation. It is never in our interest to go for litigation. We are business organizations, not litigation organizations. So that is the first and foremost thing which comes to our mind. And at our end, we are doing as much as possible for educating our claim settlers. How they should be sensitive to the need of the customer, and how they should interpret the contract as far as possible in the favor of the claimant, and how the whole process should be transparent as well as it should be professional, and no room should be left anywhere for any doubts. And even if it crops up, then all possible mechanisms should be followed, so that ultimately it ends up in an amicable resolution. Again, quoting from the survey conducted by your institution, I have seen that all these efforts are actually leading to a lot of education on both the parts, and most of the customers were happy with the claim settlement, and those who were not happy told that when they took it up with the authorities for alternate dispute resolution, it was handled well, and the dispute was resolved without any further litigation. And but it also transpired that if at all it is not solvable, then the arbitration is the first choice for all these people. So nobody wants to go to consumer courts or the civil courts. So arbitration has a great future, and with all these endeavors, like what you are engaged in, I sincerely hope that our economy, our society will benefit from all these positive actions, and we shall emerge as a developed nation sooner than later. So my best wishes again to the new degree holders, new certificate holders, as well as to their teachers and the institution in itself. Thank you for giving me this opportunity. Namaskar.
Thank you. Thank you very much, Joshi sir. We'll now, at the end, we'll be inviting our wise man, Mr. Satyendra Singh, to not only draw his conclusion, but also to bless all the people who have participated. Mr. Satyendra Singh, he joined National Insurance Company in the year 1980 as a directorate officer, and he worked there for almost 36 years, rather more than 36 years. And he was a principal at the National Center for Insurance Learning of National Insurance Company. And he was faculty on deputation to National Insurance Academy, Pune. He has also taught at IIM Indore, Mongol Datgol, Mongolia, Ethiopian Insurance Association, Addis Ababa, Amity University, Noida, ILMS, Gurgaon, IMT, Ghaziabad, and other reputed institutions. I'll request him to give his epilogue as well as vote of thanks. Satyendra sir, please.
Good afternoon. I know it's slightly delayed and we are getting close to lunchtime, but I hope all the dignitaries who had participated here, Mr. Loya, Mr. Hoda, Mr. Sanjay is of course before us, the lawyers from the Supreme Court, Mr. Venugopal, Mr. Singh. So it's been a, remarkable day of learning for me personally. And since I've been involved in this field of learning and communicating, I really feel privileged that I had the opportunity to be here. And one thing that one could discern while hearing to the various speakers, the primacy of arbitration over litigation. I mean, that is very easy, comprehensible in the sense that with the pendency that we have, the huge numbers that we talked about, some of us. But what is more important is for the future growth of the country, the ease of doing business. Mr. Singh especially talked about the institutional arbitration structure, which would hopefully be there after the amendment, and how it may lead to an entire change of scenario, better efficiency, more certainty on costs, etc. So I'm not taking points from individual speakers because, as I said, it's slightly late hours. And best compliments to the participants. Mr. Amandeep just mentioned that all of them have scored A and A plus, right? So, which is a remarkable thing, doing your regular service and studying, or even if people have superannuated, getting to learn something again. So that's something very, very remarkable. And the institution which Mr. Wahab, Mr. Amandeep, Ms. Vandana, they are all a part of, is doing a remarkable job of pushing towards a better, ease of doing business, to repeat that word because that got repeated several times. So hopefully we will have these changes soon enough. The bill gets approved in the parliament, and greater glory to the institution. All the people who are a part of it, who have been trained by it, will be the future leaders in settling disputes, especially in insurance domain, with much faster speed, and which will be beneficial to the clients. Probably the customer focus we haven't highlighted that much, but they will also immensely benefit out of it. So, as I said, I'll keep myself short because I think everybody is waiting for the next round of lunch. So, thank you very much. It's been a great day, great learning for me, and I presume for all the participants who are here. Thank you.
Thank you, Satyendra sir.
Thank you.
Very thankful to all our very distinguished speakers. I'm very thankful to all the participants. I'm very thankful to all those people who, other than the participants of ISCC, that joined today. So we end the webinar here. We close this webinar here. Thank you. Thank you all very much.
Thank you.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you. Thank you.
It was a great journey.